authority is always in subjection. You cannot have the good of the whole when a mob is ruling over another group. The only definition of the good of the whole rests in the good of the individual, the rights of the individual, when every right is duly respected. Then the society exists in a just state, and everyone is at liberty to live, as long as they do not harm or control the right of another. Remember, Madison says, the end of government and the only definition of a just government is a government that impartially secures to everyone what is their own. Article 1, Section 3, power of the people over internal affairs, constitution, and form of government. That the people of this state have the inherent, sole, and exclusive right to regulate the internal government and police thereof, and to alter and abolish their constitution and form of government whenever they may deem it necessary to their safety and happiness, provided such change be not repugnant to the Constitution of the United States. You have the unquestionable right to control your government, up to and to include the changing out of ranks. You are not ruled by those in government. You are the rulers over government. You are to operate by the rule of law, not by the law of rulers. And when those in government violate your Constitution, as we have seen it today, they are not operating as a just government. I love this part of your Missouri Constitution, because remember that last clause says, provided it not be repugnant to the Constitution of the United States. Section 4 says, Missouri is a free and independent state. Kansas needs one of those. Missouri is a free and independent state, subject only to the Constitution of the United States. That all proposed amendments to the Constitution of the United States, qualifying or affecting the individual liberties of the people, or which in any wise may impair the right of local self-governance belonging to the people of this state, should be submitted to conventions of the people. You're not even subject to future amendments of the U.S. Constitution if your people don't agree with them. By the way, that's what it means to be a free and independent state, just so you know. But what about red flag laws? Just a little preview in case you can't make it tomorrow. Or a little preview in case you want to invite somebody to come to this class. What are red flag laws? Temporary restraining orders. That's what they call them. Temporary restraining orders that seize your property without a warrant, without probable cause, based on subjective allegation only. Section 23, the right to keep and bear arms, ammunition, and certain accessories. Right, exception, and rights to be inalienable. The right of every citizen to keep and bear arms, ammunition, and accessories typical to the normal function of such arms in defense, what is this now? Oh my goodness, in defense of your property. Your person, well, let's just say your home, specifically your person, your family, and your property. Is what the right of the government? The police department, your sheriff's deputy, person, or when lawfully summoned to the aid of civil power, shall, what is that word? Shall not be questioned. Well, that kind of sort of kills the whole permission slip kind of thing, doesn't it? Shall not be questioned. Questioned by whom? Not by your neighbor. They're not talking about your neighbor questioning, are you? Because the Constitution is a reminder to the people of the limit of government. The rights guaranteed by this section shall be, oh my goodness, unalienable. Any restriction on these rights shall be subject to strict scrutiny, and the state of Missouri shall be obliged to uphold these rights and shall under no circumstances decline to protect against their infringement. Nothing in this section shall be construed to prevent the General Assembly from enacting general laws which limit the rights of convicted felons or those adjudicated by a court to be a danger to self or others as a result of mental disorder or mental infirmity. Somebody might say, well, there you go, KrisAnne, there's your temporary restraining order exception. You got a mental disability. No. That's not how your temporary restraining orders operate. Yes, they tell you it's about keeping guns out of people who have, what is that? They say mental disorder or mental infirmity, but look at that. There's a very important word in there. Adjudicated by a court. Adjudicated by a court requires due process. Your temporary restraining orders are absent due process because they take place without your presence. And they establish a standard contrary to due process where you are now guilty until you can prove yourself innocent. Not based on probable cause, not based on clear and convincing evidence. If you're a criminal, the standard is beyond reasonable doubt. It is mere subjective allegation. Remember the unreasonable searches and seizures. These temporary restraining orders operate without a warrant. A real warrant, because there's no probable cause. Remember, all five have to be present at the same time to be a reasonable search and seizure. And I'm still looking at this again today, and I don't see in there a comma that says, except unless we think it's necessary. Private property shall not be taken for private use with or without compensation unless by the consent of the owner, except for private ways of necessity, except for drains, ditches, lands, and for others, agriculture sanctuaries, private property. That when an attempt is made to take private property for a use alleged to be public, the question whether it is contemplated to be public shall be judicially determined without regard to any legislative declaration that that use is public. If the government is trying to take your property for public use, it must happen in a court with a jury. Your temporary restraining orders take your property. Private property shall not be damaged, shall not be taken damaged for public use without just compensation. Such compensation shall be ascertained by a jury or board of commissioners until the same shall be paid to the owner or into the court for the owner. The property shall not be disturbed, or the property rights of the owner therein divested. Do you see that? If they're going to take your guns from you, they either have to give you just compensation before they take them, or they have to place the just compensation in control of the court before they take them. This is your Constitution. This is not up for debate. This is not subject to your legislature changing unless they amend the Constitution. So let's talk about, that's just a little preview for you, for the red flag laws. By the way, wouldn't this also apply to the government issuing stay-at-home orders, COVID orders that shut down your business? Is that not a taking of your property? See, I had somebody tell me, oh, that's not really a taking of your property, KrisAnne, because it's just temporary. I said, oh, great, that's fine. What's your address? Just go ahead and leave the car keys in the mailbox. I'm just going to drive it around for a while. I'm not going to tell you when I'm going to give it back, but I will promise that it's only temporary. Oh, you're not going to give me your car keys? Oh, fine. I've got a gym. I'll jimmy the door open. But I'm not taking it. I'm just going to use it for a little while. I promise to give it back. You think they're going to take that? Well, the government has no right to do anything that I don't have the right to do as an individual. It is temporary, but it's still taking. And how temporary is something when they don't give you an end date? And when does temporary become permanent? When they decide to give it back? Or when you can no longer maintain it and you have to destroy it? Before they shut down your businesses, your Constitution required that you were given just compensation for the loss. If it's just temporary, then you have to give me just compensation for the loss of my business, of my property, for the time that it's missing, and you must do it before you take it. So what about these orders from your governor? By the way, your Constitution in Missouri is much better than the Kansas Constitution on these issues. So there really is no excuse. It's even better than the U.S. Constitution, so you don't need to run to the U.S. Bill of Rights. Legislative power shall be vested in a Senate and House of Representatives to be styled the General Assembly of the State of Missouri. Legislative authority is given to the legislative branch alone. Laws can only be made by the legislative branch. But what about the governor? Well, Article 3 says, or Article 4 says, the supreme executive power shall be vested in the governor. Well, does that mean he can make executive orders to be enforced by law? No. It means the governor shall take care that the laws are distributed and faithfully executed. Governors don't write laws, they execute them. By the way, the governor should never be executing a law that is contrary to the Constitution, because remember, his oath is to the Constitution, not to the law. So lawmaking is reserved to the legislative branch, and the governor's job is not to make laws, but to enforce them. But it gets better, because you might say that's my interpretation. How about this? The powers of the government, Article 2, Section 1, shall be divided into 3 distinct departments: the legislative executive, and judicial, each of which shall be confided to a separate magistrate. Here we go, you ready? And no person or collection of persons charged with the exercise of powers properly belonging to one of those departments shall exercise any power properly belonging to either of the others, except in the instance of this Constitution expressly directed or permitted, and you will not find that resting in your Constitution for your governor. It's called separation of powers. It is an essential guard to liberty. James Madison explained as they were debating on the ratification of our Constitution, there can be no liberty where the legislative and the executive powers are united in the same person or body of magistrates. Why? Think about this. What kind of government did we live under before we declared independence? Right. What makes a king? Not a crown, not a throne. What makes a king is the authority a king legally exercises. What authority does a king legally exercise? Well, the king is the executive of the government. The king executes the laws. But what makes your king different from your governor? Your king also writes laws. It's called the power of decree. So you see, our governments are established on an essential principle of separation of powers. So we have governors and we don't have kings. Because when you live with a king, liberty cannot survive. So what happens when you have a governor that looks more like a monarch than a servant of the people? You have the most violent attack on the Constitution of the state of Missouri and the people through a violation of separation of powers. How does a governor become a king with a constitution so clear? Well, it can only happen when the people don't know their constitution. And we submit to unlawful orders. How do you support this? We've identified the problems, have we not? How many of you see just how wrong these stay-at-home orders are, the shutdown of our governments are, the orders were issued by our governors and our local mayors and county commissions? How many of you see this? Yeah. Because you realize every single one of those bodies or people that I mentioned took the same oath. They are governed by those documents. Not above them, but in subjection to them. So now we have to figure out, what do we do? How do we fix this? What's the solution? I'll tell you, it's very simple. It is very simple. It may not be easy, but it is very simple. This is Alexander Hamilton explaining to us the principle of unconstitutional government. He says there is no position which depends on clearer principles than that every act of delegated authority, contrary to the tenor of commission under which it is exercised, is void. Therefore, no legislative act contrary to the Constitution can be valid. That is the same principle that applies to your Missouri Constitution. Right? We call the Constitution of the United States the supreme law of the land. Well, your Missouri Constitution is the supreme law of Missouri. It is the creator of your legislature. It is the creator of your governor. Your legislature, your governor are in subjection to the Constitution of Missouri, not superior to it. And anything that they do contrary to the Constitution is null and void. It has no authority. read that. The Constitution delegates authority to the government. We read that. If they are operating on power not delegated, they are operating absent our consent and absent any authority. Law without authority is no law at all. What obligation do you have as a people to submit to something that has no legal authority? None, except this. The ones that you mentally impose on yourself out of ignorance or fear. Remember that basal human instinct. This is James Wilson. The power of the Constitution predominates. It's why it's called the Missouri Constitution. It is the supreme law of Missouri. It predominates. Anything, therefore, that shall be enacted by Congress or your legislature or your governor will not have the force of law. What obligation do you have to submit to something that has no authority at all? Remember, the purpose of government is to protect property, not to control it. Undelegated authority is null and void. So what is the most powerful solution in a situation where you have government acting under undelegated authority? It's called peaceful non-compliance. It is the most powerful check and balance in the body of the people who are the owners of the power. Remember, we read that in your Constitution. All political power is derived from the people. Peaceful non-compliance is the people taking back their authority when the government is unlawfully exercising it. Peaceful non-compliance is not us violating the law. Because remember, if it doesn't have authority, it's no law at all. Peaceful non-compliance is not the people violating the law or acting unlawfully. Peaceful non-compliance is the people enforcing the supreme law of the land because the government is acting lawlessly. If there is a legitimate law and you act contrary to that legitimate law, are you not committing a crime?
Yep.
But your state constitution is called the supreme law of the state. Which means if the government is violating the supreme law of the state, wouldn't that mean that they're committing a criminal act as well? In the very least, they're violating that law. And every bit of history, every foundation upon which America was built says that lawless government has no authority. And that only changes when the people step up and say, we will not comply. Let's try it. Ready? We will not comply. One more time. We will not comply. One more time. We will not comply. I saw the smiles on your faces. Feel how powerful that is? That is the solution. And the only thing that limits you is this. We don't need to organize to drive around the state capitol and honk our horns and wave flags. What exactly does that do anyway?
Makes us feel good.
You know what? Servitude can feel good sometimes. And liberty is sometimes hard. We need to organize together to peacefully not comply. Do you realize how driving around the state capitol, honking horns and waving flags is actually complying with unlawful orders? Because you can't assemble outside. You can't meet together as a body. You certainly can't show up at your capitol en masse.
Without a permit.
Without their permission.
Right.
Without a lobbyist.
This is your best friend in the defense of your liberty. And if you don't have a constitutional sheriff, it's not your sheriff's fault. If you don't have a constitutional sheriff, and this, I'm going to tell you right now, this is in my humble opinion, because I told you, I teach not by opinions, not by interpretations, but through applications and facts. This is in my humble opinion. If you do not have a constitutional sheriff, you have absolutely no business whatsoever campaigning for or supporting a president of the United States. You are negligent and irresponsible if you're running around campaigning for a president of the United States and you do not have a constitutional sheriff. Because the president of the United States has no authority in your county. And your sheriff in his county is superior to the president of the United States.
That's true. Superior to everybody. I think any law enforcement.
You see, our sheriffs take an oath to support the Constitution of the United States and the Constitution of the state of Missouri. They do not take oaths to enforce the law. They do not take oaths to support the governor. As a matter of fact, your sheriff is not a hireling of the governor. Your sheriff doesn't work for the county. Your sheriff is a constitutionally elected representative of the people.
Yep.
You hire. He works for you.
That's right.
Your sheriff is not beholden to any person for a paycheck. Any one person for a paycheck. He's a representative of the people. And we need to start teaching that. We need to start expecting it. And we need to start demanding it. Because a constitutional sheriff would have never allowed your businesses or your churches to be shut down, period. And you don't know it, but there are sheriffs all over the country doing this. You see, this is Brad Rogers. Brad Rogers of Elkhart, Indiana. The sheriff stood up to the federal government. Because the sheriff is superior to the federal government in his jurisdiction. He got tired of the federal government, the USDA and the FDA, raiding his Amish farmers in the middle of the night trying to confiscate their weapons of mass destruction. Raw milk and cheese. Brad Rogers sent a letter to the USDA and told them to share it with the FDA, explaining that if their agents showed up in his county ever again without first coming to his office and seeking his permission, that they would have to come and bail their agents out of jail because he was going to arrest them for trespass. This was many years ago, and Elkhart, Indiana has a new sheriff, not because they didn't like Brad Rogers, but because he term limited out. And his under-sheriff is now the sheriff conducting the duties in the very same way. And they've never had another problem with the USDA or the FDA. This was Brad Rogers' response because they started calling him a hero. Now let me tell you something that you should realize. Defending the Constitution is not a Republican Republican thing. It's not a Democrat thing. It's not a liberal thing. It's not a conservative thing. It's a liberty thing. It's a natural right thing, and it belongs to all people.
Yep.
Look at what he says. Your local elected officials can stem the tide of federal overreach. You can put in there governor overreach, county overreach, or just government overreach, if they just apply a little backbone in supporting and defending the Constitution. Now here's Brad Rogers telling you the solution. Expect